Section 84 of the Elections Act and Article 143 of the Constitution. My lords and my ladies, let me start by submitting that my submission shall be around one, the issues framed by the court, particularly, my lords, issue number 8 on illegalities and irregularities that, if applied disjunctively as this court has ordained before, my lords, will lead to a compelling order of nullification of the elections of 9th of August 2022. But I will also, my lords, and in view of the powers of this court under Section 3 of the Supreme Court Act, delve into the interpretation of Article 143. And my lord, perhaps because this court is also the jurisprudential head of the judiciary, to see, my lords, whether there are possible sanctions or possible findings that this court can make other than the order of nullification. And my lord, that will be in my last submission. My lord, let me just touch on the second part. The second part that my learned friend Mr. Omtata will deal with will be the maths, electoral maths, the mathematics of the election. We will demonstrate by way of a PowerPoint presentation that none of the candidates met the 50% plus one vote as per the tallies that were read by Chairman Chebukati on the percentages weighed against the voter turnout and the votes cast, my lords. And that will show that if indeed no candidate attained the 50% plus one, then this court has a daunting task. One, of course, after the exercise that is ongoing, the exercise that is going on with the server, my lords, we will be asking this court, my lord, to think of the possibility of declaring a winner after the outcome of the access to the back end of the server. That's number one. But number two, my lords, patently, the results announced by the chairman of the IEBC were unconstitutional because they did not emerge from the commission. And granted, my lord, that they were unconstitutional, if the court then is unable to arrive at a result as to who won the election, my lord, then of necessity the court would then would have no option but to proceed to nullify or find that it was conducted illegally. My lord, let me just proceed because of time to the key submissions. My lord, it is patent and glaring that there was non-compliance with Article 81A and D of the Constitution, read together with Article 86E of the Constitution. The elections were not verifiable inasmuch as voting took place. The process of tallying of the presidential vote from the polling station and the issuance of Forms 34As transmitted to the constituency tallying center and finally to the national tallying center, my lords, was not a verifiable process. My learned friend Philip Murgod has spoken largely to the access that two individuals had to the system. He had spoken of one Dahir and one Kwanusu, who had access over 1,000 times Mr. Kwanusu, the PA to the chairman, Mr. Professor Githu's client. Clearly, my lords,
I would like to request the Honorable Court that we conduct this petition in the tradition, in the very long honored tradition of each counsel arguing his case without any sideshow.
My lord, it is a fact that the chairman is Professor Githu's client, but I will, because of the discomfort.
Counsel.
Address myself to the...
Yes, I'm speaking.
Yes, my lord.
I think you should treat your colleagues with respect. We all know that who is representing who. So make your point.
My lords, I will proceed. I will proceed. I will not mention Prof's name going forth. But my lords, the violation is glaring in view, my lord, of the fact that the non-verifiability of the process from the tallying center as held by the Court of Appeal, my lord, we've spoken to this severally, to the National Tallying Center of what each presidential candidate received, my lord, is a subject of an unconstitutional act. My lord, that is point number one. My lord, therefore, the counting, there was a violation of the duty to count each vote cast by an individual as contained in the Form 34A transmitted to the National Tallying Center and as uploaded to the Form 34Bs and 34C that was used to declare the result in Form 34D, my lords. My lords, granted further, that violation is also reflected, my lord, in the violation of the Elections Act itself. Because, my lord, there was a requirement that once the tallying is done and the verification done under Article 138(3)(c, it was not the chairman, but the commission that was required to undertake that process. And my lord, I want to speak to the affidavit of the chairman himself. Other advocates have submitted on the self-importance that the chairman presumed in conducting the final tally, ignoring the mandatory nature of Article 138(3)(c. This court has dealt with the question of interpretation of statutes and of the Constitution, my lord, where there's a compelling word, shall. Article 138(3)(c is compelling in nature. It does not give the chairman an option of consultation or of assuming the role of the commission. It states, my lord, that the commission shall undertake the process, not the chairman. The same term, my lord, is used in the second schedule to the IBC Act and in sections 4 and 8 of the Elections Act. My lord, if I may just read 138(3)(c. It provides, my lord, that the process of tallying, my lord, after counting the votes in the polling station, the independent electoral and our shall tally. My lord, where shall is used before a verb, citing my learned friend, senior counsel, it leads to an inevitable and compelling option. And this is what the courts have interpreted in several cases that we have handed over to the court, my lords. The cases in Kirain Investments and National Land Commission, this was the finding of the court, again citing the findings of the Court of Appeal on the same question. Wesley, Judge of Appeal, laying down the consequence of the use of the word shall as peremptory. So, my lord, of itself, any action reflected in the affidavit of Wafula Chebukati that denotes any action by himself in assigning other members work, my lord, and in eventually purporting to act under 138(10) alone without consultation invalidates the entire result that he purported to announce and invalidates the issuance of Form 34C and D in which he purported to announce the results of the election. My Lord, ipso facto, the duty to transmit, tally, and collate was therefore violated. The regulations, my Lord, 39(1)(c) of the Elections Act required two tallies, the physical tally and the electronic tally that ought to have been transmitted. Non-compliance, my Lord, is evidenced in the affidavit filed by Ciira and by the four commissioners, my Lord, and an admission by the chairman himself that the tally was not compliant with section 39(1)(d) of the Elections Act. My Lord, going forth, the complementary nature of compliance reflected from sections 39 to section 44 uppercase A of the Elections Act, my Lord, denotes non-compliance by the commission, but also an admission, my Lord, that there was no commission the moment the commission was divided and was working in different forms. My Lord, Article 3(2) of the Constitution provides that there shall be no government established other than through the Constitution, so that any violation that leads to an unlawful process, my Lord, cannot stand. And this court has the duty under Section 3 and Article 140 to invalidate an offensive action that is unconstitutional. My Lords, we submit that through the affidavits that admit the interference with the transmission system, the interference with verification, and the duty to declare the presidential election by the Commission, the result gazetted in Gazette Notice issued by the chairman, being Gazette Notice 9773 of 2022, was unconstitutional and cannot stand and must be invalidated by this court. My Lord, in view of time, we wish to submit that even aside finding that even the duty of the Commission as created and enshrined, my Lords, in Article 249, is governed and dictated by the principles under Article 10, my Lords. And my Lords, where public officers do not act in a manner donated by Article 10, then their actions must be vitiated by the court. And this is the forum where such actions must be vitiated. My Lords, the law is clear. The maxim ex turpi causa non action, which has been developed over the years, my Lord, by Lord Mansfield, initially in Holzman versus Johnson, later in Tinsley and Milligan, and now in Patel versus Misra, speak to the fact that no circumstance can allow this action to stand. The opposing affidavits, my Lord, the opposing affidavits filed by the four commissioners and the three that speak to the violation of paragraphs 5 and 7 of Schedule 2 can only lead this court compellably, my Lord, to find that this is a matter that this court must handle in the manner that lex arbitri would dictate. My Lord, this the principle, ex equo et bono, used by international tribunals to settle questions. In the local framework, my Lord, we refer to Solomonic wisdom in 1 Kings 14. The court should look at the opposing affidavits. The court should look at the misconduct of the chairman of the commission. The court will then compellably apply the dictates of fairness in this matter and find that the people of Kenya were violated by the conduct of an election outside the framework of the Constitution, through the violation of the process, through the violation of the outcome. And my Lord, we want to demonstrate to the court, before I wind up, that mathematically, and this is where the law meets mathematics, no candidate attained the 50%. If the chairman read the results that he read and the percentages that he read out of the registered voters that cast their votes, my lord. My lords, the maxim, amiable compositeur, that I shall look at after my learned friend, Mr. Omtata, presents the results, my lord, will show you that this court has no option but to nullify this election. There's no option. There's no option. Mr. Omtata.
Gather because you're all senators, you're learned friends now?
Yes, my lord, Mr. Omtata is a serial litigator and a public interest, a public defender in this country. And I respect him for that role, my lords.
And now a senator? And now he's a senator?
Yeah, he's a senator for Busia County. He replaced the Attorney General, who did not run for office.
Members of the Honorable Court, in my submissions, I will rely on the petition we filed jointly with the three others, which is dated 22nd of August. I also have submissions which I filed alone, which are dated 26th of August. And I also have a further affidavit which is dated the 29th of August. My lords, before I remark on the mathematics, I just wanted to make a small observation as regards point number 1. And I think the elephant in the room is point number 1. What kind of election does the Constitution of Kenya anticipate? That's a question that I've seen documents and videos by some members of the court telling me that even this court does not comprehend the kind of election anticipated under Article 81 and 86 of the Constitution. Short of a digital election, you cannot meet the constitutional threshold.
Mr. Mtata, what
Yes.
did you say?
I said I've come across publications and video recordings by some members of the bench who complain that the 14 days the court is given to determine a dispute concerning the presidential election is too short. And I'm saying that statement demonstrates the failure of, with due respect, the honorable judges of this court to understand the electoral architecture in the Constitution of Kenya 2010. The Constitution of Kenya 2010 only anticipates a digital election. And if we are dealing with a digital election, 14 days is too much. But if you are dealing with a paper election, a manual election, you need maybe 2 months. That's where I wanted to begin. And this election does not meet the threshold in the Constitution at all. The presidential election, the one I'm referring to, that's before this court. It's not simple. That's why you have got spoiled ballots. In a digital election, you don't have spoiled ballots or rejected ballots. And you don't even have the question of whether spoiled or rejected ballots count. It's not verifiable,
Right now, I cannot verify where the ballots I cast went. I don't know. The moment I dropped them in that box, I lost all contact with those ballots. There's no mechanism of verifying. A digital election would give me a serial number by which I could track my ballots. So I'm saying that if you look at the threshold in the Constitution, we must work towards a digital election and move away from these paper elections, which allow human interference without sometimes leaving footprints. I would now go to my submissions. I was supposed to be given some aid. Yes. Where's the...
If the time could stop running, we had supplied the electronic instruments to the court.
You beg the assistant.
Okay. I don't understand what you said. I come there. Oh, open for me the PowerPoint document. Go to the next slide. Yes, we're looking at an analysis of paragraph 26 of affidavit filed by Mr. Sunkuli in petition number 7, paragraph 226. And you can see that he's giving us, he gives data of how the KIMS kits transmitted on 9th August at 17 hours at the close of polls. He gives that figure. On 9th August at 20:45 hours, about some 3 hours and 45 minutes, he gives his figure of 13 million. Then, most surprisingly, you have two entries. There's the entry that which gives us at 14 hours and 14:40 hours. The KIMS kits are transmitting some 23 hours later, still transmitting data. And we're saying that that data is not acceptable. So we come to the next slide. I'll just run through given the short time I have. When you got that slide, you look, they tell you at 20:45 hours, on 9th August 2022, some 13,731,215 people voted. Polling turnout recorded on 10th August is 14,239,862 ballots. And on the 10th, that is the day after the voting, and we know that it's only elders where elections were taking place. Now, when you analyze that data, you find that 508,647 ballots are added on the 10th. And you saw Land Council Willis show that the audit of the register had almost the same number of ghost voters. So you can see from that data that Mr. Sunguli presents, you are able to isolate 508, 647 ghost cast votes, which are more than the difference between the two leading candidates. We've got the next slide. And if you look at the ballots that are recorded to have received, to have recorded on the next day, you are talking of some 1,665,412 curiously cast votes, which are coming out after the close of voting, and that's after 3 hours after the close of voting. So if we take the total tally now, you find that the tally is close to it's about 1.7 million votes. That spike in votes is not possible. That spike in votes is part of the problems we're having, that fellows were having access, the KIMS kits that were still transmitting data from locations that are not clear. Because the KIMS kits that were in polling stations, the voting stopped on 9th. And giving an allowance of 3 hours or 4 hours for people who are still on the queue, you would understand by why a KIMS kit would still be transmitting 23 hours after the close of elections is something that is difficult to comprehend. Also, my members of the Honorable Court, if you look at the Form 34C that has been published and interrogate the data there, if you look at the total of the variables ascribed to each candidate, the amount that you get is 110 votes less than the number that has been printed on that paper. Now, if you look at, that thing was boggling my mind. Initially, I thought it was a simple error of addition. But it has come out it was not a question of 1 + 1 = 3. Because when you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, yes, I'm on, yes, go to the next slide. Next. Yes, sorry, I forgot to, thank you for directing me. If you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, the total voter turnout in the table when you subtract from it, as given in the table, the number of rejected votes on Form 34, you get exactly that figure of 14,213,137, which in that replying affidavit they claim was an error of addition. But if you interrogate their raw data, you find that that figure is the valid figure. So the votes attributed to the candidates are fictitious. From paragraph 32 of Mr. Sunkuli's replying affidavit. So when you go on to the next slide, I've reproduced I've tried to factor in the figure that Mr. Sunkuli gives, and when you add them, you get the 14,213,137. Yet, when you add the figures attributed to the individual candidates on Form 34C, they come to 14,213,027. That is not an innocent mistake. Is a situation whereby somebody has left a trail. that they were working backwards from a certain figure we had, and they were working backwards, and so they would going to get that. And most important, I would also refer to the affidavit signed by the chairman, filed by the chairman in petition number 5. At paragraph 95 of his replying affidavit, sworn on 26 August 2022, the chairman presents the exact figure of 14,213,137 as the total valid votes cast for all the 4 candidates. So if that is the figure that's coming from the raw data, that's the figure that's carried in the affidavit, then the values attributed to each one of the 4 candidates are fictitious and cannot count. And therefore, that Form 34C is an invalid document. Go to the next slide. Sorry, next. Yes, so in that slide I'm saying, we can only conclude that these figures, which form the content of Form 34C, are cooked. You cannot have both of them in the same document. And this court should not allow that document to stand at all. And the conflicting figures, and those conflicting figures for valid votes cast of 14,213,137,000, and the other one is the one when you add the values of the individual candidates, the 4 candidates, you get 14,213,027, is evidence that the results were worked backwards to achieve a desired or predetermined outcome. Therefore, the declared percentages for the 4 candidates, no, the votes attributed to the 4 candidates and the declared and the percentages attributed to them is all fiction. Now, I go to address the question of whether you can achieve, if assuming that what in the totality of the announcements made by the chairman, any of the candidates realized 50% plus 1 vote.
Just checking on the time.
Yes. There's no display for the time, unfortunately.
According to mine, time is over. If you could just finish your slides.
Okay, thank you.
Because they seem to have lost theirs.
Okay, so a further analysis of Form 34C on voter turnout, the chairman announced, and that issue has not been retracted at the close of voting. He was answering a particular question, and a journalist asked him, as matters stand now, what is the national voter turnout? And he said, oh, that one, I can deal with it. And he said, as at the time he was announcing, it was 65.4%. And according to what the KIMS kits had reported. And he expected that value to go up when all the KIMS kits had reported and the manual had been included in it. So when you calculate that against the total voter register, the national voter register of 22,120,458 votes, you get that the voter turnout as at that time was 14,466,799 votes. The next slide. So from Form 34, the tallies are ascribed in Form 34. You get, when you factor in the rejected votes, you get a total value of 14 million.
Number? So 225 it is. The forms, we record. What do you make of the forms? Let's have 2 comments. Yes, yes.
And therefore he decided to abandon the first one, which was not signed, and went to the other one.
So whatever happened for you, one form is unsigned, another is signed,
yes,
and even signed by the.
Yeah.
So we'll just note the 2. Yes. I don't know if there is. Do you have a different opinion for those who have seen that we have 2 forms, one unsigned, populated yes but unsigned, and then one which is signed. So depending on what happened, we don't want to speculate, but we'll just have that in the report. So as we are looking at it, I think the team can bring the next, we do 6, we have 2 more to go before the break. Yeah, let's seal number 4. Let's.
Okay, thank you. Unless you are changing, that is not word for word. No. So if it's word for word, we don't need any other copy.
But of the most important is the father affidavit. Because when I did the first one, I did the petition, I did not have the information that came from. I did not have the information that came from Mr. Sunguli's affidavit. So I would request the court to pay particular attention to the father affidavit. That's why I had the benefit to compute the figures with the figures that the commission supplied. That's all my
Thank you. Compelling are the figures that finally mathematics finds its way into invalidating.
So, General, you have no leave to address the court after time. Why don't you start from there? From where? From what time? start from there.
Senior Counsel, we agreed on the ground rules yesterday. Your time is up. In fact, his time went over because he was on the PowerPoint. We noted he went over by 6 minutes. So please, yes, if you have anything, you can reply when you have time to reply. Rejoinder. I will now invite counsel in petition number 6, Ciira, Yokabi-Chege, and others.
May it please, Madam Chief Justice, Deputy Chief Justice, and other members of the court. My name is Kibe Mongai, appearing with Ms. Wairi Mukeru for Julia Nyokafi-Chege and 3 others. First of all, let me say that I'm very happy to be responding last, and particularly to have had that very good presentation by my long-term friend, Mr. Okiya Omtata. My Lord and my ladies, the petition before the court has been introduced. The petition is dated 22nd of August this year. It is supported by 2 affidavits, an affidavit sworn on 22nd of August by Julia Chege, and a further affidavit that she swore on 28th of August, 2022. We have done submissions which were filed on the 30th of August, 2022. That is when they were stamped. And we have also done a bundle of authorities as required. Now, having introduced the pleadings that we have filed, I wish to, looks like I don't have the petition, but basically the petition before the court, the petitioners are basically arguing for invalidation on the simple ground that there are so many violations of the constitutions and the electoral law by IEBC and its chairman, as the case may be, and as a result of which, those violations constitute such severe illegalities and irregularities that the results announced ought to be nullified. We have pointed out, for purposes of the specific issues raised by the court, we want to dwell with issues number 6 to 9 that were identified by the court. And to sum up, because before we go to the exact issues, is we shall basically be talking about 3 violations before we refer to the conclusion. Now, the first issue is the fact that over 700,000 people who ought to have voted during the general election held on 9th of August were deprived of the opportunity to do so. Number 2, we shall be arguing that the 3rd respondent, that is the commission, contravened or violated its duty of accountability, transparency, and public participation during the 4 stages that we shall shortly be outlining, and in a manner that it declared the results of the presidential election. The 3rd issue that we shall be referring to is the fact that the 3rd and 4th respondents violated the procedure set out in Article 138 of the Constitution in discharging their mandate of tallying and verifying the vote at the Bomas of Kenya. I start with issue number 1. The constitutional basis for issue number 1 is Article 38 and 138A of the Constitution. And in this, we are referring to the number of people, 700,000 by our count, who ought to have voted and were deprived of the opportunity to vote. Now, what is a complaint? The complaint, members of the court, is laid out at paragraphs 56 to 60 of the petition, paragraphs 56 to 60 of the Constitution. And the supporting evidence is laid out in paragraphs 24 to 28 of the supporting affidavit sworn on 22nd of August, 2022. The long and short of those paragraphs is that the petitioners are basically saying that by virtue of Article 1 of the Constitution, the people's sovereignty is exercised in Kenya by 2 major methods: through voting, and collectively we only exercise that right during a presidential elections. And number 2, by voting in a referendum. Now, under Article 38, it is expected that the right to vote for a candidate of your choice is recognized. The same way under Article 138(3)(a) of the Constitution, voting at a place appointed by the IEBC by all persons eligible to vote. Now, on that basis, Regulation 90 of the Elections General Regulations Act, General Regulations 2012, were done under the Elections Act. Regulations 90 provides, is a short provision that I need to read, that the Commission may make provisions for the voting by election officials, observers, patients admitted in hospital, older members of the societies, members of the defense and security forces on duty, prisoners and nomadic pastoralists, and other persons who by reasons of any special need, including disability, are unable to access a polling station. 2, the Commission may from time to time publish notices on the manner and procedure of the conduct of special voting, and such notices shall be read as part of these regulations. So the long and short of it, but I want to tie up with the facts, in paragraphs 50, the petitioners say no such notices were issued with regard to the persons in contentions in this particular contest. Who are those persons? Those persons include at least 500,000 elections officials. They include at least 180,000 members of the security forces. It includes those people who are in hospitals and others who may not be in hospital. But they are placed in such circumstances that special arrangements ought to have been done to ensure that they were able to exercise their rights under Article 1 and Article 38 of the Constitution. Now, why have we chosen the figure 700? The figure 700, as you will see from the affidavit, has been chosen for the simple reason that there should be no contentions about it. These figures, these are elections officials. The IBC chairman is quoted in the newspaper report that is attached to that affidavit, in fact confirming that indeed all these number of peoples will be engaged during the election day. Their engagement during the elections day follows up of necessity and in the nature of their duty that starts at earlier than 6 a.m. and ends long past the counting period, that those are the people envisaged under Regulation 90, that special arrangements to ensure that they vote would be made. It is not denied, in the face of how these complaints being made, that those arrangements, in fact, were not made by the Commission. Now, it is important to point out these regulations were made in the year 2012. Of course, it is interesting to know, faced by these complaints, how did Chebukati answer them? He answered them in his affidavit by first of all saying, prisoners were allowed to vote under Regulations 90. He says diaspora Kenyans were allowed to vote under Regulation 90. And he also says very old people and sick people would be first on queue, and so such instructions were issued to ensure that those kind of people would vote first with a little bit more convenience than others. But Your Lordships, it is important to note that when it comes, for example, that prisoners voted, prisoners have been voting in Kenya in the presidential elections, not so much because IEBC has been complying with the law, but because I believe it was Judge Lenaola, when he was at the High Court, made an order first that prisoners to vote in the presidential elections, and number two, in the referendum. And that was done. Even the reasons why diaspora voters vote in Kenya is again because of another subsequent court decision. So that where we stand today, for purposes of Regulation 90, IEBC cannot give a single instance that in support of ensuring that as many Kenyans as possible will vote for the presidents of Kenya and exercise their rights to franchise has ever done anything. There is no evidence of that. Now, during the preparation of this petition and afterwards, for purposes of these kinds of violations of the right to franchise, it is a very serious thing across the world, because as many of us are entitled, and that is why even this right was given to prisoners, to ensure that we vote. You find in very many other countries where elections have been nullified because of the issue of franchise. But you do not have a single instance, at least to the best of my knowledge, that this has ever happened in Kenya. And this could probably explain why, even after the Constitution is clear on this issue, that facilitations be made to ensure as many people as possible, and those in special circumstances, those arrangements have never been done by IEBC. It is my submissions that, given the results that were declared on the 15th of August this year, voting by up to 700,000 voters, even if that was adjusted, how many of them could have been registered and how many of them could actually have voted to the actual averages, you would still have arrived at a very big figure of more than 300,000. That directly, and on account of non-compliance with an express provision of the law, were unable to vote. Did the failure to make that accommodation, those arrangements, to ensure those people voted affect the results of the elections? Undeniably. If those people had voted, it is our submissions that the results of the elections could have been affected. And my Lord, it's my submissions that unless and until this honorable court take up that issue as a serious issue of violations of constitutional law, then Regulation 90 could as well be an empty piece of legislation. And therefore, part of the enforcement of ensuring that the universality, that the free franchise and universality of it is respected, would be to ensure that a very serious elections was violated on its account. And it is on that reason that when we read our submissions, we are urging the court to do exactly that. Issue number 2 has got everything to do with the fact that the duty of accountability and verification, as we had said, was violated at various stages. It is my submissions that there are at least 4 stages in which this happened. Number 1, stage 1 ordinarily occurs the stage between 20th, the election period. A gazette notice was issued on 20th of January to signify the commencement of the election period. That period ended on the 8th of August. Then there is stage 2, voting day. Then there is stage 3, which is a 7 days period under the procedure set out under Article 138 of the Constitution. Stage 4, in my submission for purposes of the presidential election, it is the 21 days period under Article 40 of the Constitutions that you are dealing with right now. Now, what are the stages at stage 1? The issues at stage 1, and I will link them up with how they tie to the elections, is the fact that in this particular case, IEBC, according to my clients, was supposed to ensure that they set up a technology system that was transparent enough to ensure that the outcome would have credibility in the eyes of the electorate. The one single issue that we have pointed out for purposes of that in an elections where you've said you have recognized voters using KIMS-KIT, it has been recorded, it is our submissions, that on day 1, in their affidavit, they say 6 hours, that at least 6 hours after the conclusions of voting, Kenyans ought to have known what many people voted electronically and using any other complementary system of voting. And my lords, it is my submission that the failure to do that, one cannot be able to speak of a technology that worked if the most important component that a voter ought to know, the right of a voter to know, yes, we voted. If we reach this number, this man is president. If we reach this number, this one is president, or is in the opposition. That number ought to have been given without any dispute. There should be no controversy about it. Yet the fact that you have all these controversies about the register just points out to the issue that on that critical element, there was serious failure of that technology. But it may not necessarily have to be a serious failure of the technology, in the sense that it could well be that the manner in which now you conclude voting, Forms 34A were uploaded, but the actual figures were being named on day 2. This is day 2 after the arrival of all Forms 34A. It is our submissions and my hypothesis that any person, and nowadays there are so many books that you can read anywhere and you can buy anywhere, that says how do you rig elections. If one was set out to rig an election such as this one, then one of the most important variable would be the voters register. And in this case, it is our submission that the fact that on day 1, 6 hours after the election, we were not told in a controversial manner, and after Kenyans have invested in a technology, that this number of people voted, this opened the system in the subsequent verification process to the kind of abuse that more other able people in that area have spoken about today. But that, on the face of it, appears to be where the opportunity arose. I go to the issue of still at stage 1, the issues of the nomination. We have said in our affidavit that for purposes of Article 99 of the Constitution, the presidential candidates were supposed to be subjected to qualifications under Article 99. The manner in which that was done for purposes of presidential election, the second respondent was actually not subjected to it, and at the end of the day, persons with unresolved questions under Chapter 6 is today Deputy-elect of the Republic of Kenya, arising out of the failure of IEBC to enforce the law. The next issue is the publication of a Gazette Notice number 9540 on 8th of August. This Gazette Notice in our submissions was an instrument of illegality. My learned colleague, Mr. Nyambodi, says that IEBC chairman is always inclined to produce Gazette notices even where none is required. I read it differently. If you read Gazette notice as an instruction manual, it makes a lot of sense. In this sense, that in the ordinary scheme of things, and particularly when I was working in the human rights movement, when you deal with a lot of police officers and other people on those junior ranks, this activity will be carried this way. They'll not tell you the Penal Code says this, the Police Act says this. They will tell you the forces standing order, which they are socialized to understand, says this. So this was the forces standing orders. So that for purposes of the day when this verification was being carried out under this, what we are calling stage 2, it was being, and it was published on the eve of the election. There was also the bad faith that on the eve of the elections, you publish such kind of a gazette notice that runs directly counter to the Constitution. Why would anybody do that in good faith? There was lack of good faith. Because in the Republic of Kenya, during my practice of a couple of years in public law, we are aware this is the kind of stuff that we present in constitutional division and the judicial review courts to confirm whether or not it complies with the constitutions or statute. Therefore, when you publish such a gazette notice, an instruction manual that would be deployed during the verification exercise, and the following day is a public holiday, you cannot be taken to have been done that with the best of intentions. We got to stage 2, voting day. Voting day, the first violations that we talked about, not everybody entitled to vote under Article 138 in the presidential elections actually voted on account of non-compliance with the law by the IEBC. The second issue for purposes of that day, I've already talked about it, is a voters register. That on the elections day, and we have said 6 hours, you needed to know how many of us voted. The moment that information was not provided, the system and the process was exposed to anything could happen. And actually by the 15th of August, the worst, and all that could go wrong actually went wrong on the 15th of August. And therefore this is why we are saying these violations were not just minor violations. They were violations that indeed went into the heart of what is before this court, the disputed elections. At stage 3 is what we call the procedure under Article 138. Well, my constitutional law mentor, Dr. Gibson Kamau always used to tell me, and I believe most of the people who had the privilege to be his pupils, that the Constitution must be understood in a historical context. And therefore it is important that we understand Article 138 in a historical context. What is this context? This context, my lords, is this, that we do not have an equivalent of Article 138. We do 6 elections. The Constitution has not told you this is a procedure at the parliamentary elections, or the governor, or anybody else. It is only reserved for one position, the president position. The procedure at the presidential elections. And this was to leave no room of doubt that this is how in which the verification process ought to be carried about. My lords, the process after we vote in a presidential elections, I first voted in 1992. And since that year, the first multi-party elections, after voting, of course in Kenya they tell you, vote, go home, watch it on television. You will get to know the outcome. How it has always worked is that you are there at home, results are read from constituencies, from everywhere else across the country. It is a ritual that happens every year as far as I can remember, since the year 1992. Now, what is the importance of this ritual? It is important to remember that in the year 2007, this ritual was disrupted by the events that happened at KICC. The disruptions of this ritual led to the post-elections violence, and the rest of it we are all aware what happened after that. So that it is not a simple ritual. And so that in the year 2010, when the Constitution was written, it provided for a sections and 7 days and a procedure, setting out in no uncertain terms, this is how after people vote for their president, we are going to process the issues. So that the Constitution having dealt with that issue again as that historical background, you cannot have a situation where subversion through a gazette notice is tried to be effected. That would be treason in every sense of the word. I go to the issue of what's the importance of the ritual. To the winner of an election, this ritual that we saw in this constituency, what you got in my neighborhood, is very important. Because the people, while we are seeing all this being displayed, and remember that during Bomas, the display to show Kenyans that these are the results that were coming in, this is how the figures were adding up, that was disabled at some stage. So that what effectively this meant, that the true purpose of Article 138 ends up being defeated. Defeated in the sense that for the winner goes and declares that I had the most numbers in accordance to Chebukati. And the loser, everybody else says, I do not know how you got those numbers. I actually thought I had more than you had. This is what was tried to be prevented. But it is equally important, the procedure under Article 138 for the loser. Why is it important for the loser? Because the loser, and in this case, the loser is a loser of, with say, about 6.9 million votes, quite a number of Kenyans. This is a loser on his 5th time seeking the presidency. The last one he says he lost under controversial circumstances. There was everything necessary to ensure that for purposes of these elections, if you are to lose the election, the math must make sense. It must add up. The Kenyans, those people who voted for you, must also see that you did not do very well, because it is clear these people in that other place did not vote for you as you expected. Now, but when you have now a true situation on the 15th, the dramatic events of the 15th of August, where even 27th constituency, my clients are there waiting at home. I was also equally waiting at home. Those results are not announced. Then how do the people who are supposed to be losers understand that they genuinely lost in the elections? That would strip the process of legitimacy. But it is equally important for another reason that Wallace Soyinka talks about in one of his essays. And I believe the essay is published in a book called Climate of Fear. And Wallace Soyinka, in an essay titled The Quest for Human Dignity, says that in war, it is important that those who lose a war should not be stripped of their dignity. And basically what this means is this, that even after losing war, you are not stripped naked in the sense that you are told you lost half of your country, but you must be left with the other half. That is if you are in the Russia-Ukrainian kind of situation. That is the whole idea that nobody should lose absolutely. And when the Constitution talks about fairness, about transparency, it is to enable that this is processed in a manner that everybody else would be able to understand and to process the victory or to process the loss, if it turns out that it was a loss. Now, we go to the issue number 4. I wish I could say more. I'm just trying to watch myself. Stage number 4, the final issue is the Supreme Court issue. We served Chebukati with our affidavit. And I would not say he's arrogant, because that may not be a permitted language. But the language that he used is one that shows lack of remorse. You will read the affidavit. On the issue of, why didn't you make arrangements for everybody to vote? We were talking about specific people, election officials. Then he says, oh, prisoners voted, diaspora's people voted, and all these other people voted. Now, that was not the issue. I think they are needed, and this is accountability to the Supreme Court. And that is the design of the Constitution. That now that a violation has been committed, what do you have to tell the court about it? You could not even say it was an oversight. The next one, I will recommend to the next chair to ensure it is done. There was no such thing. Then we go to the next issue. In our affidavit, the third petitioner says, I was disturbed about the events of 15th, because in the morning of 15th at around 7:30 a.m., I was shown some text that seemed to show the results that now are being announced later. Why was it disturbed? Because at that time, votes were still being counted. People are being told in constituency A, this is what people got. How does Chebukati react to that? Or everybody with a good calculator could have downloaded these forms 34A and calculated. Now, Kenya is a country with extremely low digital literacy. To say, and when such a thing that would cause concern, that there was a problem, and you say this information was readily available, leaves a lot to be desired on the part of a public officer. I start with finishing with the issue of legitimacy. It is important that winners should have legitimacy. And it is also important that the losers also should be treated with dignity. When we read the affidavit of Honorable William Ruto, he says, oh, so many people, why are you pretending that you are acting for all Kenyans? So many people agree with my victory. But it is also equally true, so many other Kenyans don't agree with it. And therefore, in a constitutional democracy, as I conclude, it is absolutely important that when you win, and Article 38 says you win it this way, it must be confirmed. Thank you very much.
Thank you very much, Council. We would like to take the submissions by, I think, 4 respondents who are supporting the petition. That is the 4 commissioners. According to the time schedule we allocated yesterday, they were to share the 1 hour. But before Council, you take the podium, we are proposing just a 15 minutes health break. Then we come back because we will hear those submissions. And if there are questions from the bench to all the submissions that have been made, they will be directed to Council. So we'll need about 1.5 hours when we return to finish today's proceedings.
On the word from Justice Lenola, could the court find out pertaining to the question of scrutiny? Because it is still
TV Muthegi wa Rũrĩrĩ. Tusirudi nyuma kwa mipaka na nchi kufungwa. Tusira na shughuli kufungwa kwa kutoweza kukutana, kwa kutengana na tuwapendao. Tusirudi nyuma.
Na kuhitaji unikinge, pata chanjo
ili tuendelee na maisha vizuri.
Na kuhitaji unikinge, pata chanjo.
Na kuhitaji